Roland Mumford with Mumford.law. We were successful in a motion practice hearing this week where we were able to compel the deposition of an employee who was out on maternity leave, and the employer tried to avoid producing them, claiming that they could not communicate with her while she was on maternity leave. Well, that is true to an extent, but not in a litigation matter. The judge held that that was a litigation communication to discussed with her about being produced for a deposition. It was not a work related activity. I think that could be subject to debate amongst other judges or a court of appeals. But in general, what can an employer do? Can an employer speak with you if you are out on FMLA leave or out on maternity leave? And what can they discuss with you about? It's limited in what they can do. These are the permissible communications that your employer can have with you while you're out on maternity leave or FMLA leave. They can have general check-ins, occasional non-intrusive communication to check on the employee's well-being or confirm their return to work plans is allowed. Occasional non-intrusive communications with you to check on your well-being or confirm your return to work plans being allowed. Administrative matters, they can discuss things with you like benefits, paperwork, where FMLA documentation is permitted. Voluntary updates. You can voluntarily stay in touch or provide updates if you wish, but you cannot be required to do so. Return to work coordination. There can be reasonable communication with you about accommodations, schedule, or reentry plans. But what they cannot discuss with you is pressuring you to return early. That would be a violation of FMLA rights. Asking you to work while you're on leave. They can't ask you or require you to work while you're on leave under FMLA. Frequent or harassing contact. They can't have regular, consistent calls, emails, or texts, and because that can be seen as an interference with FMLA leave. They can't be discussing performance or job security. They cannot discuss with you issues about performance or job security unless it's urgent and necessary, such as a reorganization. But those conversations usually can wait. So the best practices for employers are limit the contact to only what is necessary, respect boundaries and the nature of the leave, especially maternity or medical leave. Document the communication about the case in case there's future disputes. And when in doubt, they should always contact HR or the legal counsel. So remember, if you're on maternity leave or on FMLA leave, your employer can only have contact with you in certain limited situations, and it cannot be frequent, intermittent at most, and it can only be about the subject matters that we had discussed a moment ago that were permissible. Again, those are general check-ins, administrative matters, voluntary updates, and return to work coordination.